Yes, welcome to the No State Project right here on LRN.FM, the Liberty Radio Network. We are live from the fortified compound in Mesa, Arizona. I'm Mark Stevens, the website, of course, markstevens.net. And we will be giving you 3 hours of anarchy radio here today, as we do every Saturday. And we also have an hour commercial-free on Wednesdays at 6 p.m. Mountain Standard Time. I do that because it's 4 o'clock in Arizona, but when all you guys outside of Arizona switch things back, it's going to change, so it's just easier then to give my Arizona time. And we will be live this Wednesday. I believe that would be episode 10. And that is February. Wow, we're in February already. February 1st. So look for that. So if we're not able to get to you today, then definitely check us out on Wednesday. And we usually get a lot of calls too, but I only have an hour. So I try to give everybody enough time, but it doesn't always work out. It is just an hour. I'm going to go a little bit over. I don't have any hard break. It's just me. It's not on the network, so it's fine. But if you want to join the show today, it is 218-632-9399. 218-632-9399. You may also do so on Skype. That is Frank Rizzo 3. That's Frank Rizzo with the number 3 there. But do not call me during a live broadcast. During a live segment. What you do is you instant message me there first, and then I will bring you up on a break. Of course, we don't have that option on the Wednesday broadcast, so we may be able to, but still instant message me first, especially if I'm already on with somebody. We don't want that to happen there. But I discuss a few things before we start. We'll take calls in the beginning of for the next segment. Article that I just posted. I wonder if it's going to get the incredible criticism and well thought analysis that some of my other articles have. But this was a great one. When Gadsden Viperhead called into the show last week and then was reporting about what happened in court. I was finally able to get this posted a couple days ago. But the document's there for everyone to see, and I guess it's becoming a regular thing. The criticism against me is typically false, where people are just straw-manning things, or just making up stupid things, or just flat-out misrepresenting. And some are well-meaning. I have not been able to get to call into Free Talk Live to correct Darryl Perry. I don't think he's doing it maliciously. He's just wrong. Other critics are just being douchebags and trolls, but I do it because, and I address the criticisms here so that people can make up their own mind. So they have, they have it from both sides. They can see the evidence and they can make a determination on their own. And so that's what I do here, is address the typical criticisms. And this one was just so great because it really destroys the criticism, the main criticisms that I get. And so I couldn't help but use the Tom Cruise meme, or the picture, the collage there, because it's just a traffic ticket. It'll never work at anything more serious. Yeah, sure. And it doesn't matter how many documents you put up there. See, those who are honestly seeking after the truth will see that, and they'll see the evidence, and that's why it's important to not rebut all this, but to just address the common criticisms and show where it's not really a criticism. I mean, they don't even poison the well in an intelligent way. So, like what they did on the skeptics, which I have the video. Hopefully, I could try to get it posted tonight. We'll see. Where they just lumped me in with sovereign citizen freemen on land and conspiracy theory, what they're considering lunatics because they're conspiracy theorists, and just, it's not even a good way to poison the well because it's like poisoning the well with a straw man, to be more accurate, where they're taking something and lumping me in with individuals that I've debunked many times, and and that just all it does is it keeps people from honestly investigating my work. So another skeptic may look at that and say, gee, Mark Stevens is one of these conspiracy theorists, Freeman. I'm not even going to look at his stuff. Because, in a way, if I am going to be characterized, or if anyone's characterized as a Freeman on land, your first thought is, well, this guy is talking, pseudo-legal garbage. He's going back to things the Pope wrote 400 years ago. Who gives a damn? They're talking about the name in all caps, which has never been proven to have any validity whatsoever. So it's not even, but this is great because it was the idea that has been floated is that the only reason you always have to be really skeptical and tread lightly around somebody who's saying that there's only one single explanation and no other one is plausible. You're talking to a religious zealot at that point, okay? This is somebody who has no interest in being skeptical, no interest in being rational, and simply wants to keep you from looking at something so that you can make up your own mind based on the evidence. Now, these people putting out and saying there's absolutely no other explanation for why these tickets... See, the tickets get dismissed. Yes, there are critics that say that's never been done, blah, blah. Yeah, the YouTube keyboard warriors, whatever. But there are some that get a hell of a lot more views than I do that put out that the only reason, with no other explanation possible, for why these tickets get thrown out is because we're porcupines. We're just too much trouble. We are causing these judges and prosecutors so much trouble with a blizzard of frivolous documents that they throw their hands up in exhaustion. Well, Mark's just too much trouble. Just toss it out. Toss it out. But that doesn't take into account it's not a blizzard of paperwork. They are very effective and logical issues of fact that we're raising. And if a 5-page document is a blizzard, maybe you got a point. But it's not. And the Brady request is only 2 pages. So that's not. And the fact that Gadsden Viper, and this was related on the show last week, the fact is he filed the motion to dismiss/vacate the judgment. Let that sink in to all you critics who believe your preconceived notions and presumptions are more important than the damn evidence. Because the fact is, it was after a trial. After a trial. So just as before the trial, the judge always has the rubber stamp. Denied. One word. And I'm talking a literal rubber stamp now, where you just stamp the document denied. There's no work involved. Oh, this opposes the prosecution? Denied. Oh, you think there needs to be evidence? Denied. Objection, is there... Denied. Do I have to get a mental evaluation on you? Open your mouth again. Maybe you'll go to jail. This is after. So the idea that there was too much trouble, we're porcupines, no. Like everything else he accused me of, like all of his other criticisms, no. They're wrong, and anyone who says that is dead wrong. Give me the evidence. Don't just speculate behind your keyboard. Well, we're up against the break. We'll be back with your calls in just a moment here on the No State Project. Don't go away. Yes, welcome back to the No State Project. I'm Mark Stevens, live from the fortified compound in Mesa, Arizona, where we are for the next 3 hours. And also now an additional fourth hour on Wednesdays. Same call-in number. It's 218-632-9399. You can also get me on Skype at FrankRizzo3. If you disagree with something I have said and presented on their show or at markstevens.net, you're more than welcome to call with your analysis and your criticism. Please spare me the ad homs, spare me the insults. I know them all. I'm an idiot. I'm a moron. I'm a garden variety anarchist. Just get the actual argument or claim or facts that I have said are true, and we're good. We're good. You got 4 hours a week now to make me look like a fool. So we invite all who are critics to do so. Even if you're not an honest critic, even if you just you think that we're just too much trouble. Hell, I like to hear something besides speculation of why these tickets are thrown out. Especially now we've got another. The latest one was after the damn trial. So it's a pretty high burden, which is why no one's been able to do it. Even someone as educated and experienced as Scott Bales, the Chief Justice of the Arizona Supreme Court, resorting to the argumentum ad baculum that the laws apply because other people are put in prison. That's right. That's what a Harvard education will give you if you have to be an apologist for a criminal organization. But we're going to get to your calls here. We have Pat from Massachusetts. How you doing today?
I'm doing good, Mark. How you doing?
I'm doing all right. Is it wicked awesome out there today?
Yeah, it's all right, Dick. It's all right.
You're not from Massachusetts originally, are you?
Well, that's what I'm told. I'm originally here, the alleged state called Massachusetts, there, Marky.
Well, there's a little Massachusetts just came out over there. All right, well, what do you got for us today? What's going on?
Well, I just wanted to let you know, Mark, on I think it was one of them was from last year, March 7th, on basically what worked for me and what didn't work for me. When I first started finding out about a lot of this stuff, I started listening to the sovereign citizen movement. That didn't really get me nowhere. I'm not going to get too much into it, but a lot of those arguments is, like you say, the burden always falls on you, and that's a hard thing to get off of yourself. But when I started using your method, everything started working more better. But they still, like, the prosecutors and the judges and them, when you go into the courtrooms and challenging the claims that they make, I've been looked at as crazy, called crazy, like, hey, young man, you need a lawyer. Every time it's always that they want to force an attorney upon you, thinking that you always need one. But when I tried your method, just going in there to see what facts and evidence they relied on, I found out that usually it's just like you said, they say so, but when you take it to trial all the way, when you question them, it's they usually do not know what to say. They just make certain things up or whatever it is. No facts. But this is one in Malden. This was in Malden District Court. This case was a drug possession of Class B, right? And wasn't mine. Somebody left something there. They ended up charging me with it. And I took it to trial all the way. I asked the prosecutor basically the whole time, did you guys have jurisdiction to proceed? And every time I've gotten from several prosecutors, because every time I go there and I stick to asking, hey, what evidence you guys rely on to prove you guys have jurisdiction? They say, hey, that's nonsense. We have jurisdiction. We have jurisdiction. It's maybe been about 3-4 different prosecutors that I ran into in that one case that all made the claim that they had it. But when it came down to the time to prove it, none of them can do that.
Well, sure.
All they do is just
Sure.
hearsay and
Well, it's not necessarily
go ahead.
hearsay, Pat. What I would say is to him, well, look, I know you say you have jurisdiction. Is that because you say so, or because your evidence does? Which one is it? And put him on a spot.
Yep.
And when the judges, and this is something that I originally was doing with judges, because judges were usually the ones that were, the snarky ones and snapping at me. I assure you, sir, I have jurisdiction. Objection. Is
Yep.
that because you say so, or because the prosecution's evidence does? Unless this is some kind of religious witch hunt, I think this is supposed to be based on evidence. So which one is it? So for those listening, that always put them on the spot. We're using the Socratic method. I know I get teased about that, but asking somebody for the proof that their assertion is based on is not circular logic. It's a question. It's not an argument. So, when I'm assuming, have you gone to trial on this already and had the opportunity to cross-examine the cop?
Well, the cop, when I took this case right here, this was actually two. I'm gonna tell you like two if we got a minute, but this prosecutor right here, when I basically took it there and asked them for that, they basically withdrew. The judge, which was a female judge, because in the beginning there was a couple male judges. I kept asking, they all kept getting mad. Hey, yeah, we have jurisdiction. We have jurisdiction. There was even another lawyer who was like, hey, you want to be a lawyer? Welcome to the bar association. Basically they thought I was going in there to whatever it was, but basically that judge
Okay.
dismissed the case, Mark, because of the simple fact that I said, Your Honor, may I address this court with a few questions? She said, yes, you may. I said, all right, Your Honor, is there proof and evidence of the state in the courtroom? She said, yes, the state is in the courtroom. I said, Your Honor, can you point the state? Can you point out to where the state is in for the record? She pointed to the flag behind her, Mark. So when she pointed to the flag, this shocked me. This shocked everybody in the room, the officer, all of them, right? When she pointed to the flag, I said, Your Honor, it states, in the Constitution that all persons are subject to the jurisdiction of the United States. But I said, do you have any, I was like, does that apply to me though? She said, yes, and I was like, do you have any facts and evidence to prove that that is true? And do you actually have a witness with firsthand knowledge? Once I said that, Mark, she said, that's a good question. She kind of halted the proceedings. I guess she went in the back, right? She stopped the proceeding. She came in, she stopped the basically proceeding. She came back and dismissed the case, Mark. And once the case, she said dismissal, it seemed like the prosecutor wasn't, obviously too happy. He kept trying to say something. I really don't remember what he was trying to say, but seemed like he was trying to like stop her or basically ask her like, oh, why are you dismissing the case? And she just was like, when I called in a couple weeks later.
Well, hold on a second, Pat. Wait, Pat, we're up against the break, so just hold tight. This is good. We'll finish in the next segment. I wouldn't have done things exactly the same way, but I think he got it right in the end, and that's what really nailed it shut here. So we'll talk more about the dismissal when we get back here on the No State Project in just a moment, so don't go away. Welcome back to the No State Project here on the Liberty Radio Network. If you want to join the big show today, you may do so. It's 218-632-9399, 218-632-9399, and Frank Rizzo 3, and then is my Skype username, and we can throw you into the Skype, the No State Project Skype chat, and I'm just laughing because we'll bring Pat back from Massachusetts in just a moment. What's funny is that he's reporting here that the judge said that evidence of the state was the flag. So I had made a comment here that so you think I'm within the flag? Because the whole thing is you're within the state, and the state's their jurisdiction, and the flag is the state. What a stupid thing to say. You follow it up with, do you think I'm still in the flag right now? But the Phil posted, does this flag make my butt look big? That was gold. That was good. That was good. I appreciate that. Very funny. But we'll bring Pat back. And so, Pat, I wouldn't have gone about it the same way you started, what you initially reported to us about the state. But you certainly came back from that especially since the judge made such a just remarkably stupid comment that the flag is the state. But you certainly turned it around by asking for proof that the laws applied. So for those just tuning in, so the judge wound up dismissing it, and the prosecution was a little perturbed at this.
Yeah, Mark. When I called in, what was the reason for the dismissal? She said defective language or defective complaint language, something like that. I don't understand what that is, but
yeah, right. So the thing is, if it was defective language, all the prosecution had to do was refile it. Did they ever refile it?
no, they didn't refile nothing. And in the beginning, like they filed because um I basically wrote, you know how like if I go to the courthouse and be like, hey, I need a motions template so I can write a motion. They gave me a motions template, right? I was confused on it, but all I wrote down was motion to dismiss for lack of jurisdiction, right? When I wrote that, the prosecutor filed a motion in opposition, basically stating that all my claims, I'm claiming sovereign citizens and all this type of legal crap. He's basically saying that I have that has no standing. It basically really doesn't have any merit. What I'm talking about is confusing. It doesn't make no sense at all, So that was the Malden one, Mark. But then, if this is another one, and this was in Taunton. This was driving without a license. So I don't know if you want me to speak on that one yet, or.
Well, yeah, just a moment. Did you get the dismissal in writing?
I got the yeah, it was in they gave me a report, a little paperback, and it was in writing.
Can you?
But I know usually the dismissals that you get that I see on the internet, like when you said motion dismissed granted, they didn't file it like that in printed form, but it was still in written form though. That I don't know who wrote it, but it said defective language and it says the initial of the judge there.
Yeah, scan it and send it to me. I'd like to post it.
All right, I definitely do that. And the second one was the driving on a suspended license. I was allegedly operating on a suspended license, Mark. And when I went to court, I learned though to keep my mouth shut because in the beginning when I was learning this, I was telling officers, hey, you don't have jurisdiction, and I see how they use it against you in court. It only makes you look even worse or whatever. They try to make you look worse, but So I even told the officer, I said, hey, if you want to go and you want to go see what happens to court, and you can go. So he didn't end up showing up. But this one, I put in your motion to dismiss the complaint for full fact of conclusions in law, Mark. I didn't put the Brady request, but I put that motions in at first. And when I went there, they kept giving me other court dates. I kept asking about the hearing or what's going on the motions and certain things like that. They basically try to deny it. Then I filed the motion in limine or the limine. Is that how you pronounce it? But I basically filed that. But Mark, when I put the thing is, they don't like it when everybody's in the courtroom. They save you for last. That's what I noticed. They saved you for last. They didn't want nobody in. And it was just me, the prosecutor, the judge, and I guess one clerk in there. When I filed the limine, I handed the copy in to the prosecutor. He said, why do you keep filing all these papers into the courtroom? I said, sir, I want you to stop harassing me. I want you to leave me alone. I want you to dismiss this case, And because in the beginning of the driving a letter license, I kept asking questions like, oh, is this criminal, civil, is there a victim? They kept saying, oh, we don't need none of that. We don't need a victim. We don't need nothing like that, I asked him, do you have jurisdiction? He says, yes, we have jurisdiction again. So mind you, we go in.
Wait, one second. Pat, let me just jump in here. We're never just asking him, do you have jurisdiction? It's always, remember, the prosecution has the burden of proof. Has the prosecution submitted sufficient evidence to prove jurisdiction or to prove that the Constitution and Code apply to me just because I'm physically in Massachusetts? So don't just leave it so open-ended because you generally don't have a lot of time to speak to them. They have very little patience, very poor coping skills. They do not like to be asked questions or challenged. So that's why we have to we have to go right for the throat. Has the prosecution submitted sufficient evidence to prove the Constitution and Code apply to me just because I'm physically in Massachusetts? Yes or no? And you take it from there. So anyway,
Well, there was a judge. The first judge I had, it was like an African American judge. His name's Judge Phillips, but he's a tough judge. So mind you, he was there. He said, "Hey, I'll dismiss this case if you pay $150 today." I said, "Your Honor, I said, Your Honor, I'll pay you $500 as long as you provide me the proof, evidence, and facts that this prosecutor is supposed to have. I'll pay you the money right now." And he just was like, "Oh, pay it." He couldn't. He really didn't know what to say. You know, he just was like, "Oh, we'll hear it again. I guess we'll come back out and hear it again." But what I said to that judge, because I remember there was a conflict of interest in the last case, I said, "Your Honor, you're not even supposed to be on this case." He said, "Why is that?" I said, "There was a conflict of interest between you and my attorney, or the last case last time, and I was involved with it." He says, "Who was the judge? Who was the lawyer?" I was like, "It was that lawyer that just went up in front of you." And I guess that lawyer just had a case and went up in front of that judge. And right after that was done, they called me, and I told them, and I was like, "Yeah, that's the the lawyer that you was with last time. You guys were both working, whatever it was." And he says, "Okay, then I would have to recuse myself." So he basically recused himself because of there was an issue before that I faced this judge in, and it was a drug charge, Mark. And basically what happened the whole time was the results came back as something different. And basically the lawyer I had, he encouraged me to plead guilty, basically to take probation and all these things. So after I came to find these things out, I was just like, "Oh, this is I'm at least gonna have to stand up for myself. It's not fair. I know what they're doing is basically not right, whether it's my opinion or whatever." But I that time when they basically was like, "All right, admit to violating your probation and we'll let you go." This is what they told me, Mark, right? And my lawyer's telling me, I'm like, "Hey, are you sure that I'm gonna be released if I go home? If I admit?" They was like, "Yeah, we'll let you go home if you plead guilty, and we'll give you probation, whatever." So I did that. Mind you, this judge, it seems like he was getting ready to give me some time, a sentence. I pleaded guilty or admitted to the violation of not paying them on time probation, right? And he went to go say, "Hey, how much does this case hold? 2.5 to 5 years, whatever." He was getting ready to try to go do what he was gonna do, and I was like, "Your Honor, may I please address the court with a few questions?" He said, "Yeah." He said, "Hey, you know where me and you stand?" Because I would always go to court late sometimes, Mark. So he'd automatically lock me up for being late, and then all this. So I was like, "Hey, can I ask the court a few questions, Your Honor?" He said, "Yeah." I was like, "Your Honor, I feel this is illegal. This is a huge conflict of interest between you and my attorney. I feel you guys are working together." Once I said that, Mark, he basically got up and was like, "Oh, I'm gonna have to recuse myself, and we're gonna have to give you another judge." And I got another judge, and I still ended up admitting to the thing, but I got out that day,
Okay, well, I'm
But
sorry.
that was that.
Well, we have to
that,
finish off here. My name is Mark Stevens. We'll be back in just a moment. Okay,
okay.
so we got a couple minutes just to finish. Let me kill the feed there. Okay, so how did this end?
Basically, it ended with that judge he basically recused himself. He got up and recused himself, Mark, right? Now that same judge that recused himself, now when I caught a driving with suspended license, I put your motion in. I ran into this judge now. This is when I put that motion in, the motions in, they really wasn't trying to like hear it, right? That's when I told him, I said, "All right, Your Honor, matter of fact, you're not even supposed to be on this case. There was a conflict of interest." That's when I pointed out whatever happened between the last case between me and that judge and the attorney. And when I said that, Mark, he stopped everything and he was like, "All right, we're gonna have to get you another judge," and I got another judge again.
So are you
You
still
know,
dealing with that problem?
no, they dismissed that one. That was a driving. Sorry
Oh,
about thing, but they dismissed that because after I put that motion in limine. Now this was like a American judge or whatever. He listened to it. He said, "Son, you have to learn how to follow the rules of the road." He's giving me all this legal advice and stuff. And I asked him, I said, "Your Honor, may I please, address the court?" He said, "You may." And I brought up the Constitution, which just states that, the all persons are born and they're subject. I said, "Do you guys have any factual evidence that it applies to me?" And the judge really didn't have time, like whatever. He really didn't want to make time to listen for it. He was just like, they dismissed the case,
Nice.
but
Good. And you have proof
yeah.
of
So
that?
that
Do,
was
do you have do you
that's
have that in writing?
uh the motion. No, I have the document. That one I didn't get nothing in writing. I just got the motion that I filed in. It was stamped. It was just stamped, and even where it says the signature of the judge, he didn't write his signature. But and I did hear something like you can't trust that sometimes because anybody can just place a rubber stamp, so you don't even know if it was the judge that wrote his true signature or what. But all I got so far was a stamp. It says from Taunton Division. That's on the driving auto license one.
Oh, okay. Well, see what you could do about getting in writing. I'd like to see that.
Yeah, well, if there's a way that I could call them in and be like, hey, can I, like some like your advice on that? If call in, I'm gonna call in and see what was the reason why really it was dismissed. You know.
Yeah. Well, hey, I gotta bring somebody else up.
Yeah.
I'm glad you called, and I'm looking
And
forward to seeing the scans so I can get that posted.
all right, in 2 more seconds, I actually have one more coming up, and it's set up for pretrial on March 8th. I already put in the Brady request in the motion to dismiss
Good
full
man.
fact and actually the limine in already. So I'll keep you up to date with that too, maybe
Well,
on
the
the site or
in
something.
limine is kind of premature. You have to wait until the prosecution, at least 30 days, so that you know that the prosecution is not responding to the Brady request. So,
Yeah,
okay,
they
so just keep
basically
that in
didn't.
mind.
But go
Oh,
ahead, Mark.
okay. Hey, I appreciate the call. We'll talk to you again soon.
All right, talk to you.
Bye. Jay,
Hey Mark, how you doing?
I'm doing good. I'm gonna put you on I'm gonna mute you up, but we're coming back in about 30 seconds. Okay.
All right, sounds
All
good.
right. Yes, welcome back to the No State Project. I'm your host, Mark Stevens. The website, markstevens.net. And the number is 218-632-9399, 218-632-9399. I forgot to mention that from one of the greatest bands ever, one of my favorite, Derek Trucks killed himself this week. And I didn't even know this. I'm getting this because Alex Knight, the third, who's been on the show before, posted something here, a response that he'd actually been attacked by the IRS a few years ago, which that's enough to drive somebody to suicide. Those people are animals, and I shouldn't say animal. I say that more that they're predators without any they're predators. They have no empathy at all. They don't give a damn. So I was really sorry to hear about that. It's just one of those weeks where there was 2 or 3 other celebrities that passed away, and Derek Trucks, of course, was the one that caught my eye, and I should have mentioned that earlier. And then, of course, Mary Tyler Moore passed away at age 80. I think she had been a lifelong type 1 diabetic. So it's sad to see them go. And wow, yeah. And having the IRS in your life is not a pleasant thing at all. They're horrible, horrible people. I'm just doing my job. Yeah, well, so is John Gotti. So is John Gotti. Just doing his job. Just doing his job. We don't buy that any more than we buy here that the double standard. It's okay to lie, steal, kill, and cheat people because you call yourself a government. And for those pseudo-skeptics out there, just asserting that you're a government or saying there's a government is not evidence that there is one. And no amount of opinion and appeals to tradition is going to change that. You need facts. You need evidence. But he's been on the show before. Welcome back, Jay from
Hey,
Texas.
Mark.
Hey, how you doing today?
Well, we're going to try something new. I am actually using Skype for the first time, as you can see.
Well, I can,
And,
but yeah, and, for everyone else, yeah, hopefully this works out. We still
yeah,
have
yeah.
callers
I was having
holding.
all those problems with my phone, and I tried to do Skype before. I just couldn't figure out how to get in, and so I finally figured it out, and here we are.
All right,
Um,
well, it sounds a little off, but it's better than it's not bad.
Now, should I turn off Liberty Radio, or then I won't be able to hear you? Is that right?
No, you can hear me. You're not listening to me from Liberty Radio. You're listening to me directly on Skype.
Yeah. Okay. All right. Well, I can hear something in the background. I guess that's just a delay.
If you've got the feed going, yeah, but I can't hear it, so I'm good.
Okay. Good. Then I'll fix that real quick, and I'll just put it on mute. There we go. Okay. As you know, I sent you a couple of emails. We were talking about the whole property tax issue, and I found something in one of your old archives, um, and it was the Jameson who managed to get his registration like zeroed out. Do you recall that?
I do.
Okay. There was a gentleman in here by the name of Pete who commented, and it's rather lengthy, but he basically lays out what he sent to his powers that be. And hold on a second. Okay. You hear me okay now?
I've been hearing you fine.
What happened? All right. Um,
We
are
got
you
to
still
get
there?
Yeah, we got to get to it, Jay.
Okay, sorry. And I was just wanting to get your take on that. I don't know if you had a chance to look at it or not, and what your take on his approach was as far as sending this paperwork to them. It kind
I
of
did
addressed
not.
all.
I get a lot of stuff, and unless it's somebody that's currently under attack, I usually do, I do have the time for that. But when with things like that, I have to dedicate my time to those who I'm working with that are currently under attack. So a lot of the stuff I don't always get to go through. That's why I usually will say, "Hey, send me the cliff notes," because if it's something that seems to have merit, then I'll do what I can to make the time to look into it.
Okay, I understand. Well, per our discussion from Wednesday, the emails that I sent you, and one of the questions I wanted to ask you, and we got cut off, was whether you notified the people when you were recording, and you said it kind of depends on, whether it's a one person state or, and then later said that it's kind of inadmissible anyway, which made me say, well, what's the point in recording it if for nothing else? Just to refer back to, because you can't hold them to it later down the line to address it in court.
Well, we're using it. We're able, even if we just have a statement of facts of what was said. If they want to cry hearsay, that's fine. We still have sufficient facts that, if taken as true, entitle us to at least a trial or hearing. And so we can put them on the stand, and they can. Did you say that? We can still read their statements back. Did you say that's way beyond my pay grade to prove the laws apply? Did you say that? And if they lie, say, no, I didn't say that at all. Oh, so you said yes. You are able to present evidence and prove the laws apply just because I'm physically in Arizona. They're still on the hook for the evidence. So even if we ultimately can't use the recording against them, we can still question them. And because any opportunity we have to question them, that's been the problem with taxes, is getting the damn agent under oath to testify, because they shield them so much. And look, I speak from personal experience. I know of one situation where someone got an IRS agent on the stand. The scumbag judge in Wyoming did everything he could to discourage that Stephen Sharp, the U.S. attorney, from doing it. He says, I'm advising you not to put this witness on a stand. Stephen put him up there anyway. The judge said the witness wasn't competent, and that's why they protect them. And so any opportunity we have to question them is fine, even if we don't ultimately have the recording to use against them. But I will go out and say, again, if it's a two-party recording state, fine. And it's a state agency, they're recording it anyway. If it's a one-party one, tell them if you want to be able to use it later.
Mm-hmm. Well, I got a real kick out of the archive of at the very beginning of the call. They said this will be recorded for posterity or for their purposes. And then when you notified them that you were recording, it's like, oh no, you can't record. It's like, well, you are. It's a double standard. I don't care why you're recording, you're still recording, but it's okay for you, but not for me. So I thought that was pretty funny. So I guess what I'm looking at is if I want to notify, because I want a paper trail, and so if I want to notify the tax assessor, I should do it through like through Brady material.
Well, you don't use Brady material for anything other than a criminal complaint or indictment that's been filed in court. But what you're going to do is, in writing, you're going to ask the questions that I would normally ask on the phone. And you're going to ask him, I know that please confirm that you operate this way, that just because I'm physically in Texas, your constitutional laws apply to me. They'll say yes. Follow up. Do you have any evidence whatsoever? And by evidence, I'm talking facts, not legal citation, not further argument, not appeals to tradition. Evidence. Relevant facts that have a tendency to prove your proposition. Ugh, how many times do I got to say that, Jay? I don't mean to you, but and then wait for a response.
Right. So yeah, I'm going to ask that initial question. Do you work on this premise? And when they will respond by saying yes, then I ask them to provide me with that evidence, with that proof in writing. I want something tangible.
Yes. Yeah.
It's going to be
yeah. And I mentioned you posted something online about it, and I think I mentioned to you on the show Wednesday. It really is. There's several purposes, and I think it's going to help immensely. Going to the city council and saying, look, even though they may not, and I would suggest sending it to them also so that they're directly involved with this, and say, look, even the county commissioners are unable to prove that because they are the ones that are sending the tax agents out. They are ultimately in charge at that level. They are the boss. They are in charge. Remember what Hopper said in A Bug's Life? First rule of management: everything is your fault. So get to one of their county commissioner meetings and confront them with it, and then I would use that against them. Look, even they didn't know, and they're the boss.
I mean, I don't think I need to explain to you the juggernaut that I'm going up against, and I hope you can understand my repetitiveness and me calling in and asking these questions because I want to have my ducks in a row.
Well, sure. Well, Jay, just hold on a second. We're up against the break. We'll cover it again in more detail for everybody in the next segment. My name's Mark Stevens. You're listening to the No State Project. We'll be back in just a moment. Yes, welcome back to the No State Project. Second of 3 hours of anarchy radio. Anarchy being the rejection of the concept of a ruling class, a violent ruling class, and the double standard used to prop it up to misdirect your attention from what's really happening. We reject the idea that it's okay to lie, steal, kill, and cheat other people for no other reason than you call yourself a government. And I hopefully get that video posted about the skeptics today, if not Monday morning. And then Monday I should also have the video about how I being lumped in with pseudo lawyers, and I've mentioned on the show many times I'm not a lawyer. I don't purport to be a lawyer. I help people defend themselves, but I'm not a lawyer. I'm not an attorney, and I'm very upfront about that. And unlike what has been laid at my feet, I do not give a guarantee, and I have absolutely never said that working with me will go one of two ways. You will either have your complaint thrown out, or you will go to jail for contempt. Never said that, so not true. So just real quick before we get back with Jay, and we are taking calls at 218-632-9399. I wanted to read something from the article, something I found, and I agree with this about skepticism, and I consider myself a skeptic, at least for the most part. The true meaning of the word skepticism has not, and this is from, and I don't agree with a lot this guy puts out, though he has some entertaining videos, Brian Dunning of Skeptoid.com. The true meaning of the word skepticism has nothing to do with doubt, disbelief, or negativity. Skepticism is the process of applying reason and critical thinking to determine validity. It's the process of finding a supported conclusion, not the justification of a preconceived conclusion. And yet, my work seems immune from this particular process, even from skeptics. That all rhyme or reason, all logic, all critical thinking goes out the window, because what I do here on the No State Project is show that there is no government, there are no states, because I don't go with a preconceived notion that they already exist and then try to get the evidence that fits it. I look at the evidence that's available and see if that evidence tells me that there's a state, and the evidence tells me there is not. That's why their rules don't apply. There's nothing magical about them. Calling it legislation doesn't make it any different. It's just a word. Where is the reason and critical thinking? I have a skeptic using an appeal to authority and tradition in the same sentence. Ay. Welcome back, Jay. We're talking, Jay from Texas. We're talking about going after or defending against a property tax attack potentially, or maybe heading one off, and I think it's best just to give you go over the steps again for those just tuning in or those who have not heard it before. You may actually be in a situation where you have to pay and then bring an administrative action or claim for the money back, and then if that's denied, have to take it to court. But either way you do it, you still need to build your statement of facts, and that has to be by confronting them on paper and in writing and in person, and asking them the questions to prove that their claim is true. I can tell you from experience that what you want to do, and we've done it, I did this in Maine, they're invariably going to tell you, sir, I do not write the laws. I only enforce them. If you have a disagreement, you'll have to go to the legislature. Now, you can point out that the legislature is not the one that's making the determination that the laws apply to you. They just wrote them, okay? It's the agent at the local office that's doing that. But knowing they're going to say that, I would say to you and everybody else, go to the legislature. Actually call and write to the chairman of the Senate and House committees for taxation. Now, maybe means and ways, but you want the tax and revenue. You want to go to them, and you want to put it to them so you can say, I already did, and they can't prove it. I did that up in Maine. They pulled that crap with me. Go to the legislature. Already did. You want the names? Here you go. So it's kind of a preemptive thing. So do it at the same time. Get it out to the so-called legislators, and you could then use that and say, I'm trying to resolve this in good faith over here. I knew that they would say something like that, so I went directly to the source of these laws, and they can't prove they apply to any. In fact, they don't even think they have to, which is more evidence of bad faith.
Exactly. Now, wait a minute, what's going on here? Oh, I'm having an echo issue for some reason.
All right, well, while you're thinking of that, I just want to point out that you want to keep track of the date and time that you spoke to them. If you have video, fantastic. Go see them in person. And then you also want to go to the county attorney. So you've got the treasurer, you've got the assessor, and whoever else they say is responsible for that assessment and the collection. You also cover your base by going to the county commission, and you go to the county attorney. Now, I'm working with somebody on the East Coast in Pennsylvania. That's what I did. We went to the legislature, we went to the city attorney because they told me to, and the county commissioners, and I went to the city. Every single one that they said was involved with that decision, I went to. And none of them could produce a shred of evidence. And even, I mentioned this recently, the city attorney, after the county commissioners told me to go to her, told me point blank on the phone, I am not qualified to make that decision. She was not qualified. So just for those, to be clear here, everybody, the city attorney, who has an advanced university degree, probably a very educated, smart woman, told me in plain English she was not qualified to determine whether the Constitution and laws apply to someone just because they were physically in Pennsylvania. And yet she does it every single day. Oh, the dishonesty, the bad faith. So you want to cover your bases is what I'm saying. Go to all the individuals that are involved in or could be involved or they could say are involved in the process and get them on record not being able to present the evidence and prove that their claim is true.
Okay. Yeah, I've gone through a lot of their codes and the Constitution and ad valorem, and the whole spiel. And of course, the whole time in my head, I'm going, still haven't seen anything that says that this applies to me.
What if you did?
They use words like person and personal property. They never use the word private.
But what if they did? What if they actually used your name, Jay in Texas? What if they actually passed a law that said Jay in Texas has to give us 50% or give us $5,000 a year because of the property he has physically in Texas? Would that mean that it applies to you?
Only if they can provide the evidence.
They have to provide the evidence the Constitution applies just because you're physically in Texas. Yes, because that is the basis of their tax laws. They'll tell you in their form letters, too. The basis of the authority to tax is the Constitution, and the legislature, through the authority from the Constitution, passes laws that they use to carry out that taxing power. So that's why, well, Mark, why do you keep talking about the Constitution? Because you guys do. It's your claim. You're the one claiming that this gives you a right to do ABC. That's why. And you have no evidence. And no, we're not going to accept on this show, no rational person would, an appeal to tradition. Well, Mark, the courts have ruled. Who gives a damn about what the courts have ruled? Have the courts made a determination on the facts that just because you're physically in Texas, the Constitution and Code apply to you? Did they determine that based on the facts that you were able to challenge? Oh, you haven't. Well, every case is fact-specific, so it doesn't mean anything. Do you really need to explain these things to adults, especially if they're claiming to be skeptics? Is my work so offensive to people that skeptics will throw out what's the basic principles of skepticism just so that they can feel pride in making fun of somebody they don't even know? Well, we got to move on. We got some other callers, so I do appreciate the call. Jay, keep me in touch, and if you need me, want me to do some help by making some of those calls, I'm happy to do so. But hey, we get some call to Shane's. We'll be back here with your calls in just a moment here on the No State Project, so don't go away. Hey, Jay, appreciate the call.
Yeah. Hey, listen, I appreciate it too, and I may take you up on that. I'm going to see what I can develop on my own as far as these phone calls to the powers that be, and see what I can dig up on them. Like I said before, I just want to have my ducks in a row. I want to know what to say, who to say it to, and have those rebuttals in place for their fallacies and their BS.
Yeah, well, listen to the other call of shames and don't hesitate to Skype me, and I could just type the questions out for you.
Fantastic. All right, take you a break and get with these other people. I want to listen and see what some other people got to say.
All right, appreciate the call, Jay. Jay in Texas, so we'll follow that, and hopefully Jay can get into a county commissioners meeting, especially if the county attorney's there. He can confront them. We'll be back with your calls in just a moment, so don't go away. Welcome back to the No State Project. Someone just posted, I'm really glad that, I'm not an IP kind of guy, but yeah, you can always download my stuff for free, but I would hope that people can help support the show, and I do appreciate the support that we do get for the show. But at least, if you even, I know some people, they'll download the stuff for free and they'll still throw me something. I appreciate that. Let's hope that can continue. It seems that there's been more free downloads than I've actually, gotten sales of. So, yeah, they're getting more views on my damn website. So somebody's doing good with my material and getting a lot of it. It's like other people with channels, which is great. They're promoting my work, but they're getting 10 times the views that my videos get. know how that works. But I'm glad the message is getting out there. Get to your calls, which you can also join at 218-632-9399. Skype is also Frank Rizzo 3. So we have area code 818. You're live on the No State Project. What's your name? Where you calling from? I know you've been patient.
Mark?
Yeah, there he is. What's your name? Where you calling from? Looks like L.A.
Hey, Mark. Yeah, L.A. My name's John. I just want to start off by saying, I've been a fan for a long time. I've listened to you. You told me how a lot of things. My question to you now is, and this may really make me sound like a chump to a lot of people, but I've been fighting a 20-year-old child support case. My question to you is, will your protocol help with a case that old? I mean, have I already lost any chance of, regaining my life back?
Well, these are never easy, even at the beginning. Domestic relation stuff is always extremely difficult. Jurisdiction still can avoid a judgment that was even 20 years ago. It kind of depends who filed for the divorce.
Well, she did. She filed for divorce.
Okay.
And here's my thing. I know I've learned that California is a little weird as far as civil. A child support case can fall under civil and or criminal. But if this is a civil case, then they would have to have standing for it to be legit, which they don't have because I never heard her.
Well, she's claiming a breach of contract. I'm sure she probably laid that out in the petition. Now, you can still, she's on the hook for proving that just because you're physically in California, the Constitution applies, and that would give the court territorial and personam jurisdiction. And she'd still be on the hook for that today if you were to challenge. You'd more than likely have to file, like a petition for a writ to get that, or have to, when you file to have it thrown out, if they reject it, then it would go up on appeal, and so you'd have to handle that in the appellate court.
Well, I think the catch here is that it was filed by the state because it was, she went on aid. We had a verbal agreement when we got the divorce, and then after she went on aid, the state came after me as they do, and assumed, I don't know if they assumed, but they said that there was no evidence of the agreement that we had. So, since then I've kind of been stuck behind it all. I really feel in my gut it's wrong. According to what I've learned from you and other sources, it is wrong. It's just a matter of, getting in there. I've spoke with the attorney on the case, and I asked him a question about procedure as far as the state properly serving me, and he said that there was not to worry, that the state handled everything as they should have. But I don't ever recall receiving any of that information that's required, because he's supposed to go to the state and then get permission from them to sue me. And from what I understand, I'm supposed to be notified, and I don't ever recall being notified. So, that's kind of reason for the call. I mean, I really feel like I'm in a bind here as far as, just jurisdiction at the most. There's, like I said, there's no standing. Even if they filed suits against me, there would still have to be standing, wouldn't there?
Well, if if one of the state attorneys filed, yes, they have to have standing if it's a civil proceeding, but there still has to be, even if it's called criminal, to be an adversary proceeding, there still has to be a legal injury. And there has to be a sufficient number, a minimum number of facts to set forth all the elements of that. And that the Achilles heel for them is they can only accuse you of violating the rule. They can't show any evidence that it applies in the first place.
But they would still have to prove that I violated this rule, right?
Well, they'd have to be able to prove that you violated the rule. They have to prove it applies in the first place, not just assume it does. Because if you're just assuming the rule applies, you can't prove that it legitimately that it was violated.
Okay. So if I have questions, I mean, do I have to file a motion, or does it really depend on the judge? Because I actually have to go. I've been seeing a commissioner on this for the last 21 years. We've gone back and forth a couple of times. And, you know, the children are grown. The oldest one is 30 years old. The youngest one is 25. So, but at the beginning of the month, I had a court date, and I objected, as she offers that I can do if I don't agree with her judging, and I'd like to be a judge. But my question is can I just, you know, I have court in just a couple of days, and would I still have to file a motion to get the judge to see it, or can I actually go? I've heard of people going in before the judge and asking a question and getting ruling.
Well, you'll have to file a motion to dismiss based on lack of evidence proving jurisdiction.
Okay. That's what I'm actually going to purchase some information from you on that. So that was the reason for the call. I do feel more comfortable. Mark, I appreciate all your time and everything you do. And
all right.
I'll probably be here Wednesday to listen again.
I appreciate that. Let me know how it goes.
I will. Thank you so much for your time.
Oh, you're welcome. Call again. Okay. Number is 218-632-9399. 218-632-9399. I'm not going to just. I'm going to say it again. This is nothing personal to anybody. If you want to join me live on the air using Skype, don't just call. I will instant message me first, and then I will bring you up on the show. I've gotten a few people that are incessantly call, and I'm please. I'll bring up. We got plenty of time. We're only halfway done with the show today. I will bring you up on a break. So that's the way we're going to do that. So again, the number's 218-632-9399, and Skype is Frank Rizzo 3. We'll be back with your calls in just a moment. Yes, welcome back to the No Stay Project. I'm your host, Mark Stevens, author of Government Indicted. Oh, I see what I need to do. That just reminded me, Matthew from Down Under, g'day, mate, just reminded me that I need to remind everybody that, yeah, I went back to using the Facebook, and I don't like it, but we're giving it a shot, that and Steam It. So I posted, I didn't post there for a while because that and Reddit just seemed to be a complete and utter waste of time as far as getting more exposure. Reddit is a cesspool. I can't stand it. I don't even know where to post there because anything anarchy related, it gets downvoted so hard you can't even see it. I don't know. That's the thing. Is my work so god-awful offensive to people that even people who think the state is a criminal organization, when someone like me comes around and can demonstrably show that there's no such thing, it's so offensive that you have to piss on it and downvote it? What did I downvote it to oblivion? It was just a complete waste of time. What's the point on posting on Reddit when no one's going to read it? So I did it, for the first time in a number of months, and then I also posted on Steam It. And Steam It's fine. It's just not as bad as Reddit, but I've noticed that I get downvoted pretty damn hard there too. So, somebody explain to me, when your numbers don't increase at all, you get absolutely no increase in numbers when you post somewhere, why you should continue doing it and spending. At least I know it doesn't take that much time. But so far, the way it is, the only time that the show gets any traction whatsoever, it gets any views and subscriptions, is on YouTube, which is why it was always such a bad thing to have the YouTube, get hits for copyright stuff. So I'm very careful about that stuff. And I just want to point out, you could still comment away on my YouTube videos, the new ones I'm posting now. I just am going to disable the comments because on YouTube, but I do link up there. You can link on the article itself, You can always link. You can always go to the link for the article itself. So it's right there at markstevens.net. So you can, and you don't even have to be a member of the forum, but it is also on the forum. So there are two opportunities to post comments about the videos and articles that I do. You don't have to. It's ridiculous to give people a venue for just trolls. And I'm not saying that I would just necessarily delete it, but my gosh, at least I could do something about someone copying and pasting, this huge block of text. Every video that he does. Look, if you think I'm a scammer, I approach me in real time. I'll take anybody on. Hell, I'll go on another live show. But my gosh, there can't be any legitimate criticism. Oh, you blocked the comment. I blocked the comments at the very start, not in the middle of a crap storm like some people do. If I'm wrong, hey, and when I've been wrong, I corrected. I got someone. Rudy Ogden, I put his father's picture up there. How the hell was I didn't know. His father was, I didn't realize it was an old picture of his father because, I figured it was more Rudy's age, which it was, but it was his father. So when I'm wrong, I take it down. So that's there. So I am on Facebook. I am on Steam. I don't think much is going to come from either platform. If anything, if people are going to hear about the work, it's going to be through YouTube. So, hey, but I don't want to discourage anybody. If you want, please keep sharing, keep doing that, and posting it in other places. That's great. I just like to see some traffic from it, but let more people. And the idea there is that more people are going to be challenging these people. More people are going to be challenging them on the moral foundation on which and show that they are criminals. But I know he's been patient. We have area code 719. You're live on the No State Project. What's your name? Where are you calling from?
Jason, Divide, Colorado.
Jason, where did you say you were calling from?
Divide, Colorado.
Oh, I'm just going to put Colorado. What do you have for us today?
Well, I have a smorgasbord of people kind of attacking me. I kind of want to hold on to one particular. Right now, I'll try to make this quick. It's a bit of a long story, but I have a mining claim, and I ran a guy off of my mining claim. And he turned around and went to the cops and filed a restraining order against me. And I went to my hearing, and the judge found against me. So now I have a permanent restraining order against me, basically for a guy that was trespassing on my mining claim, where I have fences and signs and gates. It's a small operation, but it's a decent operation. We use equipment and stuff. There's valuable stuff there. And a question, I guess, concerning this particular matter is that usually I'm fairly new to your method, but you've got me on your method. I knew who these people were, but so the county has filed criminal charges against me also concerning this matter. So they decided, and one was actually a felony to start with, and then they never filed the felony, but I have a assault charge, misdemeanor, that the county, through a county officer, that she filed with the judge and stuff. I guess my question is how, and is it even possible to attack that kind of jurisdiction with this kind of case when there actually is a supposed victim?
Well, first, let's just point out that, you've mentioned my method, and John mentioned, the previous caller mentioned my protocol. I just want to point out that I'm proud of my work, but I'm not taking credit for all of it. I am using a Socratic method and keeping the burden of proof on the accuser. The distinction is I'm not allowing for a sacred cow. I am not doing like the critics do and these pseudo-skeptics and accepting that there's a sacred cow that I can't apply the process of skepticism to, that I can't, I'm not supposed to challenge that. We have to accept that it's true. No, my response to that is fango. But It's just not the way I'm going to do it. And anybody who wants to do it that way is screwy. So the point is we're using an established method of showing that someone does not know what they're talking about and applying it to a sacred cow. I got to ask, how did you...
Understood.
Well, how did you... Well, it's not just for you, but it's for people listening. But how... I got to ask, before we get into the jurisdiction and whatnot, because it's a common thing. People think, well, there's a victim. Of course there's jurisdiction. No. We'll go through that. But how did you remove this individual from your property?
Basically, I stood in their way, and I essentially, I don't want, because I'm in a court case right now, but the video I have shows everything that happened. So essentially, I touched his elbow and turned him around.
Is that what he accused you of?
No, that is not what he accused me of. He accused me of all kinds of stuff, and then he got so hurt and pain and suffering and damages. But the video I videotaped the whole thing, and it just doesn't show that. And I brought the law up to the judge and said, look, you're allowed to, the Colorado law, I don't have it in front of me, but states you're allowed to use a certain amount of force in order to protect your private property, and this wasn't excessive or anything. I wasn't violent with them or anything like that.
Yeah, well, okay, well, we're up against the break, so just hold on 1 second. We'll be back with the No State Project here in just a few moments. Don't go away. Welcome back to the No State Project. Working to help bring about a voluntary society by pointing out through logic and reason, looking at the evidence without a preconceived notion, without any sacred cow, that those that call themselves government are not, that they're just men and women forcing us to pay them. Following the data, whatever it says. And the data says the evidence isn't just men and women forcing us to pay them. What does that tell you? Looking just at the facts, what does it tell you? No speculation, no argument. What do those facts tell you? Damn criminals. Criminal organization. Which is why we can answer Jason from Colorado. It doesn't matter if there's a victim. So welcome back, Jason.
Thank you.
So this is a very common thing that comes up. And people think, common law, there's a victim, jurisdiction. How does having a victim in 2017 prove that a written instrument from 1787 applies to us today? It doesn't. Now, that doesn't mean for a second that we advocate violence, aggression. We, do no harm. We're just saying that while there may actually be a victim in this situation A, that doesn't mean that this organization is the proper party to hold them, to seek redress. So while they may be able to point to a corpus delicti here, that does not prove territorial, personal, and subject matter jurisdiction, because they're still accusing you of violating a statute, right?
Correct.
So
yeah, they are, and this restraining order, I've appealed it thus far. So, and from what I've listened to you before, you can bring up jurisdiction even upon appeal. So I've appealed this restraining order, and it's going into the district court of Colorado since it was a county court before. And there, I have a couple questions in there on how to deal with apparently they're having a hard time. I've ordered the record, and this thing is costing me $500-600 to do all this, but apparently the record they're having a hard time transcribing the record, and it's due February 7th, and I don't have it yet, and so it has to be filed with the court by then. I'm curious if you had any advice on how to handle what if there's a motion or something I should put in if I don't have this record, these transcripts pretty quick.
Well, you just file a motion to file the transcript late because the person who's transcribing it is having a problem, not you.
Okay.
It should be fairly easy. I mean, we had Tyler in California, and I haven't posted this yet. He was having a problem with the motor vehicle out there, and he called the show a few weeks ago, and they found him guilty even though he had not gotten noticed. So I worked with him on the phone during the show, and he filed a motion to vacate the judgment, and it got granted. The judge vacated on the grounds that he hadn't gotten noticed. So those are pretty basic things that they usually don't fight you too hard with. So here, I wouldn't imagine that since it's not your fault that they would hold you accountable for it.
Okay, so as long as I get a motion in there, some probably before the 7th, before the time is up.
Yeah, and let them know what the transcription had said. I'm curious though, on but you didn't file a motion to dismiss or challenge jurisdiction or anything like that when you went to your hearing for the restraining order.
No, I have not. Like I said, I'm fairly new to this, and so I did not file any of that. I showed the video that I had and presented my evidence, and she basically just, they do what they want. So,
well,
that's what she did.
They tend to, but we have to be pretty effective and zealous when we're doing this and making our objections when necessary, and calling them out on their BS, so that even if they are going to rule against us, we have a pretty good chance on appeal. As criminal and corrupt as they all are, since they still operate on a lot of them under the presumption that it's supposed to look good. But hey, then no matter what you do, no matter what the judge says, they still rule against you. Hey, I had a judge here in Phoenix say that on appeal, there was no right of cross-examination in a traffic proceeding. I just said that. He wrote it down. Now, everyone you show that to, now, of course, this obviously he's figuring, what are you going to do? What are you going to do? You're going to take $325 out of your pocket to go file a special action against me to get this thing reversed? It's not like you're going to get your money back. You're not going to get your filing fee back. So you get me reversed. You still gave my system. You still gave the machine a few $100. So that's why he didn't, and that's the only reason why he didn't do it. Some of us aren't going, but so, yes, I know they do that, but still, in the majority of situations that we're in, we do prevail.
Right, and I guess, and that would be my question. So at this point, with this restraining order heading to appeal, what would you suggest I do? You do the motion to dismiss the whole, what you have? I haven't gotten any, I have your book, but I have not got any of your other writings and your templates and stuff.
Well, you have to do you're gonna have to do an appeal brief, but it's not something that you can really. I mean, I can send you a template for that. That's easy, but it really helps to have the transcript, to be able to do that. And for your appeal, what you want to do is you want to make sure that you only have 3 to 5 max hardcore errors that, on their own, not only do they not are they not based on the judge's abuse of discretion. These are things he did he had no discretion over. That's paramount. 2, the error must be so bad that on its own it disposes of the judgment. Those are the criteria that I think every appeal should have to keep it as short as possible. You don't want to be filed. This isn't a murder trial. You don't need a 400-page brief. You didn't have 2 weeks of testimony and things like this. There's a very simple thing, probably a half hour to an hour trial, if you can call, or hearing. So those are the 2 main criteria that I look, when I'm looking for errors that I'm going to put in there. Jurisdiction can't, subject matter jurisdiction, and it can't be waived. So So just because you're raising it for the first time on appeal doesn't mean you can't. So yes, you're right about that. So that's the way I would do that. I would get a motion to dismiss and a Brady and discovery request in as soon as possible on that misdemeanor, though.
Well, yeah, and I freaked out and I hired a lawyer on that one because one was a felony, and so I kind of jumped the gun on that a little bit. So I have a lawyer on that misdemeanor case, and I'm starting. So I have discovery. I've gained discovery on that. By all rights, this district attorney or the prosecutor, whatever they're he should drop this. It doesn't show assault in any way, shape, or form. And I'm not not a violent person. I just wanted this guy to leave, and because I knew he's a thief that he is. So, but they're going ahead with it, and so I have a lawyer on that, and I'm thinking. Again, I've heard you. I've gone back and I've downloaded and I listened. And I'm thinking of maybe just putting him on as a standby counsel. I'm not sure that he's going to do the right thing for me.
I wouldn't think so. I would not think so. I wouldn't count on it. I've had people. I've had one in particular I mentioned before, and I believe it was Colorado. Called me on the phone crying, couldn't believe what his own attorney did to him, and how he just basically signed his entire. He just signed his whole life away. He now has a felony conviction without a shred of evidence. Even the prosecution knew that, and I'm not talking just about evidence jurisdiction. They had no evidence of any kind of wrongdoing. Period. But they took a large amount of cash from him, which the attorney applied some serious psychological pressure to him, which disgusts me. And the whole thing about a felony is, remember, if they don't indict you and they just give you a felony complaint, you have the opportunity to put the police officers on the stand prior to a plea. So always remember. All right, well, we're up against a break. My name's Mark Stevens. We'll try to get to everybody. We're running out of time here, as usual. But we'll be back with calls in just a few moments, so please don't go away. Yeah, I got to run. I got to bring some people up. But, yeah, do what you can. If he's standby, you have a chance. If he's not standby, then you're right at his mercy.
Right. Okay, and then that's what I'll try to get him to do. So I know once I get the transcript and I write my brief, I should just put in my brief there that challenging the jurisdiction?
That's your biggest one right now. The other thing that you can do is that the video evidence didn't support the judgment.
Right, and the video evidence does. I don't even know how it got this far. I don't even. I've got other cases. I've got it like in Colorado Court of Appeals. I have an appeal against a agency action. So I've taken that far. I've boxed them in fairly well. We'll see what happens. I figure they're taking 4 months to screw me. So they're taking a long time.
They can. I had one in Maryland take 6 months. 6 months. And this is on the website to make an adverse ruling. And we had him dead to rights. We had the agent on the stand under oath testify to not having any evidence. She said it in plain English. They still, but it took 6 months for this idiot to write up the explanation, which was something he could have copied and pasted in a couple minutes. It was just, so the time it takes isn't necessarily a factor, but hey. Most of the time, they still work out. That's kind of an anomaly there. But I got to run. Let me know what happens with the attorney and what happens in court.
Can I ask you one more real quick?
Gotta be quick.
What happens if they don't? What happens if the transcript is untranscribable?
Well, you can still file the brief without it, but you're going to have to do things. I would start writing things out to the best of your recollection of what happened and. Make sure, because you can still file the brief without it but if they're saying it's untranscribable, that's not something they should kick it out because, they shouldn't kick it out because of that. If anything, order a new trial. But it's not your fault.
A new hearing.
A new hearing, rather, because it's not your fault. So,
right.
But you still have the fact that the video evidence, one, you can still do jurisdiction, and two, you still have the fact that the video evidence does not support the finding. So you should still be able to prevail on it. You can still get your appeal in, and those are good issues.
Okay.
All right,
I appreciate it. What I get for a template? What would you suggest just to kind of get me started?
Email me for the email me. Well, just if you get the motion to dismiss template, then what I can do is I'll comp you, which I'll just send you a copy of the appellate template, which you can then copy and paste some of the issues from the motion to dismiss into the template for the motion. I mean, for the appeal.
Okay. So
All right.
Get the motion to dismiss.
Yeah.
And I need to email you.
Yeah, just email me. Well, you can get that at email me, and it's on my it's on my store. It's under the store on my website.
Okay. I appreciate it, Mark.
All right, no problem. We'll talk to you soon. Thanks, Jason. Yeah, welcome to the third of 3 hours of Anarchy Radio right here on LRN.FM, the Liberty Radio Network. We live from the Fortified Compound in Phoenix, Mesa, Arizona, for this January 28th, 2017. We will be live this Wednesday, of course, commercial-free, episode 10. That will be February 1st. And we will start that show promptly at 6 p.m. Eastern Standard Time. You know, with all this stuff that's going on, I decided let's play this for just a second. So I'm going to ask my caller to just stay muted up for a second. So this is about a minute and a half long, but it's funny, but it's also sad because it's so damn true.
I pledge allegiance to the flag of the United States of America. Thank you very, very much for letting us little kids live here. It really, really was nice of you. You didn't have to do it. And it's really not creepy to have little kids mindlessly recite this anthem every day and pledge their life to a government before they're old enough to really think about what they're saying. This is not a form of brainwashing. This is not a form of brainwashing. This is not a form of brainwashing. This is really the greatest country in the whole world. All the other countries suck. And if this country ever goes to war, as it often wants to do, I promise to help go and kill all the other country's kids. God bless Johnson & Johnson. God bless GE. God bless Citigroup. Amen.
Very good, kids. Now come and get your Ritalin.
Wow. Yeah, that whitest kids you know, the Pledge of Allegiance, but sad because it is so true, and it really hits home that how they promise to have kids at that age promise to kill the other kids from the other countries. Yeah, that's. You wouldn't think a show like that would have something like that would have such an impact that all these years later it still has political relevance. But good on them. That was a good call. But we have your calls. I'm not going to give the out anymore because this is going to be a pretty quick hour. We got a lot to get to. We're even going to have an update from Robbie, who in Portland, who is going to trial on Monday. Well, he's got a hearing. He's got court on Monday. I don't know exactly what it is, but he'll let us know when we bring him up. But we are talking now. We have Michael calling in from Maricopa, Arizona. Welcome to the show, Michael.
How you doing?
Yeah, there he is. Hey, and since you're here in the valley,
I'm here.
Isn't the weather outstanding?
Absolutely. Beautiful.
Yeah, it's absolutely beautiful, and so Dan wanted me to mention that for the haters. So for whatever that's worth, it's fantastic weather, and I'm stuck here in the house for a little bit. But hey, after the show, I can maybe. Hey, I'm also hoping to get out and do some jamming later, but that's to be seen. I know I'm supposed to post that video, so I'm kind of torn. But anyway, what do you have for us today?
Well, I gotta take it.
Yeah, this is not working at all. The audio is absolutely dreadful.
When I went,
yeah,
is it bad?
It's pretty bad. Damn.
What about now?
Well, it seems that we'll see if it stays like that. We'll keep then we'll keep you on. If not, we'll have to find another way or another day.
Okay, no problem. Okay, so I went to arraignment. The guy basically pushed me. He told me I was going to plead not guilty, and I was representing myself, and set a pretrial. And I think it was a couple days after that is when I started watching your stuff, and really it was like, oh my God, there's people out there that think the same way I do, because I've never met anybody. But trying to figure out what I need to do first. Should I have a motion to strike, and then the motion to dismiss package, or
that's the way I do it. I would do that, that together with, and it comes with the discovery request and Brady request.
Yeah, okay. Should I put them all at the same time, or have the motion to strike and then wait for another arraignment?
Well, what you want to do is I have the instructions with it. You file the motion to dismiss together with the Brady request, and then I can also, and let me know in the note when you get the stuff that I also have a template to strike the plea. However, did you try to plea, or did you stand there and refuse? Say that I'm not going to plea until XYZ.
I didn't say anything. He basically just told me what I was going to do, and I'm like, what? Okay.
Okay, so he basically
signed these, and
so he basically bullied you.
Yeah, he just did it. He didn't ask me guilty or not guilty. He just told me. I'm like, what? That's never happened to me before. So I was thinking maybe he saw something in the file that I wasn't seeing, or what.
And you hadn't filed a motion to dismiss or anything like that?
No, nothing.
Well, maybe he's just one of these authoritarians that he's had a few people come in that get it into their head that fairness requires, that there's evidence and the burden of proof is kept on the prosecution, and that you're entitled to supposedly to know the nature and cause of the charge of proceedings, and that when you do plea, it's with voluntary and intelligently after the prosecution has established that there's jurisdiction to require it. So they just go ahead and they preempt that by just saying this is all you're going to do. Sometimes even have the clerk say, you will not see the judge under any circumstances until you enter a plea. California, you're not going to see the judge. You're not even going to file paperwork until you pay us a bail. You're not. So this guy is just, a bit more outwardly authoritarian. But you can still clean that up because he's obviously bullying you, and he's not. It's not fair in the sense that you didn't have an opportunity to even question whether the prosecution had evidence to prove jurisdiction to even require an arraignment.
Yeah, he didn't ask me anything.
He just bullied you through the process. So that I would file the motion to dismiss, Brady request, and the motion to strike the plea.
Okay. All right. Well, I'm going to try to get that ASAP.
Okay.
Is there like a time limit on that shit or stuff, or?
Well, the sooner the better. You obviously, a motion to dismiss you can file. We now have, evidence from just a few days ago that I posted on the website. You can file it after the trial and still get it granted because they, obviously there's supposed to be a full record. There was a trial in quotes, but a trial nonetheless. And so.
My ice cream.
Oh, ice cream. Well, then, hey, that's going to take precedent over there. It's they do have non-dairy ice cream, which other than the sugar that they're using, not nearly as bad for you as regular dairy ice cream. So I figured I would throw some veganism out there this week.
Yep.
So, you can get that stuff at markstevens.net. And if there's a problem, you can always email me at markstevens@mail.com.
Oh, yeah.
Or you can Skype me, which you have my Skype username now. which is Frank Rizzo 3. And
Oh, man.
All right. Yeah, we're up against the break. I appreciate the call, Mike in Maricopa. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM. Hopefully, we will be back with Robbie to give us an update on what is going on in his situation. But in either case, we'll be back with somebody in just a few moments. Don't go away. Yes, welcome back to the No State Project. For the few people out there who don't recognize that bumper, that's the great Link Ray, and that is Rumble. I had planned to play that at the jam. I got the jam for a few hours the other night. Not everyone could make it. It was just me and the drummer, so I played bass guitar. But it was still fun. Still fun. But hopefully everybody makes it next time. But, hey, it's always fun to get with the guys and jam. So, anyway, just real quick before we bring Robbie up, somebody's asking me if there's any new information about what's happening with Adam Kokesh. I have no idea. Last I had spoken, he was looking at making some kind of deal. But I hadn't heard back from him whether he did or not. So, I don't know. You have to check with Adam's page on Facebook or check out his YouTube channel to know, because I have no information. I haven't had contact with Adam in several months, so I don't know. And he's got a big thing coming up. He'll be able to give us the details. Welcome back, Robbie from Portland.
Hey, Mark. How you doing?
I'm doing well, especially since I'm down here in Phoenix, where the weather is it's pretty damn nice. It's pretty nice. I can't kid you there. It's I think winter is finally ending here. We're getting a little, it's going to start getting warmer again. So we cry out here when it gets to 45 degrees. So.
Yeah, it's been colder than that here in Portland too. So I'm hoping it gets warmer now.
Yeah, but Portland is a lot more vegan friendly.
Yeah, there's a lot of vegan restaurants, and it's very easy to find vegan food here. Cool. Paleo as well.
I need to come back to Portland. It's been probably 8 years since I've been there, and I would love to do a workshop up there, and we'll see what we can do. But what's going on Monday?
On Monday I have a hearing that they are calling a trial. I went to court on, I think it was Thursday. Yeah, Thursday. And it was basically more of the same stuff, prosecutorial misconduct. Prosecutor lied on the record by saying that the previous judge had answered any questions that I could possibly have. And then the judge believed him. So the judge wouldn't listen to any of my objections or wouldn't respond to any of my clarifications. He kept saying they had jurisdiction, but he wouldn't offer any evidence to support that claim. And he finally said, we're going to trial on Monday. So, even though I told him I wasn't prepared, that I would never wish to go to trial, especially I wouldn't want to go to trial without a lawyer, obviously because I'm not trained, but I just want to be informed of the cause and nature of the proceedings. He ignored it. So, the good news is that a previous judge did say that prosecution would have to prove jurisdiction at the trial, but I have a feeling that he wasn't talking about applicability of the code.
No, what they're talking about is trying to prove beyond a reasonable doubt that you were in Portland. And,
yeah.
Obviously, I'm pretty certain that, you can handle yourself on cross-examination. You're going to object prior to the witness being put on the stand. I mean, you have the prosecutorial misconduct, you have the motion in limine, and then you have your objections there in person when they try to put him on the stand. And do you know the two questions to get him declared incompetent?
Not off the top of my head. I have them written down somewhere.
Oh, okay, and we'll have this show, and I can always, Skype it to you. Very important, because remember, this prosecutor is insisting, and they're going to insist that the witness has personal firsthand knowledge. They're going to insist that. And you make your objection, they're going to overrule it without any explanation. When it comes time for cross-examination, the first question is, did you determine on your own that just because I was physically in Portland that the Constitution and Code applied to me and you had jurisdiction to arrest me? He's got to say yes. They will let him say yes to that question because it helps the prosecution. The next question is what impeaches him for you. What evidence, if any, did you rely on to prove that just because I was physically in Portland, your Constitution applied to me? That will send the prosecutor and judge out of their chairs.
Okay.
Now it's just a matter of you getting through the gaslighting.
Yeah. So even though they'll impeach the witness at that point, I assume that they will still allow the testimony.
Yeah, well, you want to, yes. You're going to, when they do that, you can say, excuse me, is the process, this is exactly what I'm talking about. That objection right there is now more proof beyond any doubt whatsoever that this man or what this prosecutor knowingly put a witness on the stand that wasn't qualified to testify against me. That is prosecutorial misconduct. It's on the record and you should be prosecuted. But you also are bringing out, are you actually saying your witness is not qualified to say that I broke the law?
Right.
They may not allow you any discussion, but these are some of the questions. You want to get your clarifying questions in if you can, if they're going to allow it. If they don't allow it, then you say, excuse me, just so I understand, so I can continue with my cross-examination if I'm allowed. Did you just rule that this witness was not qualified to say the laws apply to me? I wish we had more time here, but remember, they're going to object that it calls for a legal conclusion and he's not qualified to testify. Their question didn't ask for a legal conclusion. It asked him for the evidence his legal conclusion was based.
Yep.
Okay, this is a critical time, and this is something that everyone should be spending time with, a lot of time with on the role playing, because this is critical. And just you'll be able to testify the same as so many of us on the show have done. They do it every time. You guys say, Mark, as soon as I asked that second question, the prosecutor was out of his chair. Yeah. And so now it may be, what's the judge going to do? Is he going to allow you to continue doing a cross-examination, which you can then say, I would move to strike his testimony because you just said he wasn't qualified? And if they say, well, he's not qualified to give legal opinions, he's qualified to testify to the facts, what do you say to that?
Well, is it a fact that he made the legal determination that because I was physically located in Portland, the statute applies?
You say to him, no, Robbie, what you say to him, then let him answer the question, because it's all I did was ask him for the facts his argument or his opinion was based on. The question, the second question, the first question calls for him to agree that he made a legal conclusion on his own against you, which is not up for dispute because it's exactly what he did. He said you violated the law. He's saying that's a legal opinion. The follow-up question was just, do you have what evidence do you rely on? Now, that's why it's such a scumbag move for the prosecutor to object on grounds that it calls for a legal conclusion. Hey, dipshit, did you even listen to my question? I'm sorry, but we'll be back. We'll finish. We got to do we'll be. I usually don't use that language on the show or even at home, but it seemed appropriate here. But this is what you have to expect from this guy. See, if it's not thrown out and they force you into this sham trial, it's all leading to that question and how they're going to handle it. That second question.
Okay.
So it's important to do the role playing and focus your role playing today and tomorrow on that and really get good at that, because the same principles that we're discussing now regarding the cross-examination are still going to help you prior to the cross-examination.
Yep.
It's all a matter of asking a question and asking a clarification. Let me see if I understand you correctly. I asked him a question for the facts his argument was based on, and you're objecting on grounds it calls for a legal conclusion? Seriously?
Yeah, how does that make any sense at all?
Sir, and you could say the only thing, because he is impeaching his own witness, and he is now giving you evidence he's committing a crime. So you don't have to strenuously challenge him on this. It could be, let me see if I understand you correctly. I already said this witness wasn't qualified to testify because he lacked personal knowledge. Now you're in agreement with me. Yeah. Hey, I want you to answer very clearly here, sir, because now I have a self-authenticated record that I can present to the Bar Association to have you disbarred. Didn't you fight me and say that your witness was qualified when I said he wasn't? Okay, didn't you fight me and object when I filed for prosecutorial misconduct because you were arguing without facts and without a competent witness? You did. Okay, did you just now object to the competency of your own witness?
Yeah, they already hate me. They're going to hate me even more, I suspect.
Because they're just going to see you as a smart aleck kid who is getting the best of them. Instead of they're a bunch of lying snake scumbag criminals, and you are not bowing down to them. You are calling them out on it. But when he gets up and objects, that's your moment to shine. Because all that work has led to that, and they took the bait, which they do every time. Judge,
they have to, don't they?
I'm sorry?
They have to take the bait, right? Like,
they do it every time. If they allow him to answer the question, okay, which I've never seen or heard of before, they could still be the first ones to allow him to answer that question. What could he possibly say that's responsive?
Mm-hmm.
There is no evidence. What if he says you have a driver's license?
Oh, so does that mean if I didn't have a driver's license, then the statute wouldn't apply?
Or did you know I had a driver's license when you first approached me?
Yeah.
And that you're leading to, so you're telling me evidence, let me see if I understand the witness's answer. Is it correct that you think the driver's license is evidence proving your Constitution applies to me? And he goes, well, yeah. Really? How so? Explain it. That's a common one we've discussed here on the show, 100 times.
Yep.
But you ask your clarifying question, which you can ask clarifying leading questions to the witness. Let me see if I understand you correctly. You think that the driver's license is evidence proving your Constitution applies. That's right. Great. How so? Explain. And if that doesn't stop the cross-examination, boy, they are really trying to gaslight you. Because that would freak me out.
Yeah.
I mean,
they're definitely trying to intimidate me.
It would be very unusual if they allow him to answer those questions. That's why I say we're deliberately asking certain questions, knowing how they operate to get them out of their chair and object to their own witness. And welcome back here live on the No State Project. I'm doing my best to get everything in, and I think it's very important, the issues that we're talking about and what's happening on Monday, this this dog and pony show called a trial that they're going to try to have against or force Robbie into participating in on Monday. So the off-air commentary, I think, definitely check it out. And I want to keep stressing that a big focus of our role-playing should be on this moment when we're cross-examining a police officer, because these same principles and how we're going to address that are still going to be applicable and help us have an effective arraignment or a pretrial. We're leading the prosecution and the judge, because the judge has probably denied that there's prosecutorial misconduct, and we're leading him to a point where, despite all of our good faith objections and the motion to dismiss for prosecutorial misconduct, every step of the way, Robbie, they're disagreeing with you, saying he does have proof. He does have a competent witness. And so when you ask him that second question and the prosecutor objects to his own witness, that's a bad spot to be in. That's really it. And yes, they will get very, I go on a limb here. The tempers are going to flare. And it's going to be a matter of intimidation to get you to back off of what you just did to these two seasoned litigators. And
so,
sorry?
Can can you clarify that a little bit? Like, what in your experience are the tactics that they use once you bring that up in court?
The most common one is the judge in a fit of rage. Well, first he's going to, without any explanation or a discussion from you, period. This is a worst-case scenario, the most common, which is unfortunate. But it doesn't mean it's over. It actually works pretty well in the end. He grants he sustains the objection. You then ask to clarify or move to strike his testimony as incompetent. The judge, in a fit of blinding rage, denies your objection and then ends the cross-examination right then and there and declares you guilty. And you don't have, yeah. Now, let me just break this down. I'm looking at time. This is not always a bad thing. In fact, most of the time it's a good thing, because what he's doing is he is denying you effective cross-examination. He's denying you an opportunity to put on a case, because once the prosecution closes, which is after you're finished cross-examining, in this situation, you have an opportunity to put on a case. You can recall the witness. He's not allowing you to do that. And those are pretty bad. And he is accepting the testimony of a witness he said was unqualified on an objection that had nothing to do with a legal opinion. You were asking for facts. So these are pretty bad errors for the judge to commit, and we usually get that thrown out, reversed on it. But we have had that many times thrown out on appeal because, like I wrote in Adventures, it's two conflicting decisions from the judge, and we have a denial of cross, which is automatically reversed. We also have a denial of a defense.
Right.
So these are pretty bad. That may not happen here. It is the most common one. And when I say blinding rage, I mean almost to an aneurysm and a stroke kind of anger. But they probably, look, from what they've done so far, they've allowed you to argue a bit. They've denied it. So it's probably not going to go, whoa. What the hell is... So it's probably not going to go that way. I don't know if that came out over the air, but it almost blew me off my chair. Whoa. So more than likely what they're going to do is they're going to allow you to discuss the objection like we were talking about off air so that you can – so let me see if I understand you correct. You're saying your own witness is not qualified to testify. Well, he doesn't have personal knowledge the Constitution and laws apply to me, which I don't understand.
Right.
If he says, no, he is not able to give legal opinions. Okay, so he's not qualified to give legal opinions like I broke the law? You do understand you allowed him to answer that first question, but you're not allowing him to answer the evidence it was based on. So just keep your head clear and just ask those questions to clarify and get to what the main issue is. He put a witness on the stand that everyone knew was not qualified.
Yep.
And if they say, well, he is only here to testify to the facts, you can say, I asked him for the facts, you nitwit. But you also have to remember, he is not there to just testify to the facts. He is not someone who just witnessed certain things happen. He actually made a legal determination. The Constitution and laws apply to you, and you broke them. You broke the law. That's a legal opinion. Every single piece of prior testimony is open game. That's fair game on cross-examination. Competency and credibility. Remember that. Your cross-examination, you have every due process right, substantive or procedure, whatever you want to call it, to get into his competency and credibility to testify as a witness. Especially when they fought you so hard to get his butt on the stand.
Right. Now, how does the jury play into all of this?
You should be explaining to the jury and playing to the jury. See if there's someone in that jury that is responding to you. There should be at least one. And say, look, I'm not trying to get away with anything. I just want them to meet their burden of proof. And if you don't believe that they met their burden of proof, you have to acquit. I said, the fact is, and this is like the fact that you're going to see, you can telegraph this. when I ask a certain question of evidence to the witness on cross-examination, I'm telling you, Mr. Prosecutor here is going to object and impeach his own witness. He has fought me tooth and nail to get that man on a stand, and I'm telling you, with 2 questions, he's going to object and declare his own witness incompetent. And when he does that, you know that reasonable doubt has been more than shown, and you have to acquit. I would be explaining these things to the jury as well, especially when I'm making objections, look directly at them. More than what may happen is that you'll make your objection because they know what you're going to do, and they're going to clear the jury, and they'll order you not to explain your objection until they clear the jury. So you make sure to let the jury know if it goes to the jury. You let them know on your close. Let me tell you what happened when they cleared this jury. The judge declared the witness incompetent, but doesn't want you to know that. Well, let the prosecutor scream mistrial.
Yeah, because then they can't prosecute again, right?
Oh, they can on a mistrial. Mistrial magically erases what happened. It never happened for the purpose of double jeopardy.
So even if I object to the mistrial?
You can object to it, they'll overrule it, and they could do it anyway. If they want to charge you again, you're going to do the same thing. In fact, what I would suggest, if something like that happens, since you'll have a transcript and you have the judge impeaching the witness that he doesn't have personal knowledge, that he's not competent, I would use that if they refiled in the higher court for not only prosecutorial misconduct, but a malicious prosecution. And let's say, even if it has to be in the form of a mandamus, prohibiting the prosecution from putting a witness on the stand he knows is not qualified.
Yep. Okay. That's good stuff.
I know we're going to have at least one media rep there, so let them know if they're able to go. And please, let us know on Monday just that you're okay.
Yep, I will.
Don't leave us hanging like so many people do. So what questions or concerns do you have that we need to take care of here on the show and when you start doing role-playing, so that we can make sure that when you go in on Monday, you metaphorically beat the living hell out of these people?
Yeah, well, admittedly, it's not something that I've done much investigation into the actual trial portion because, being coming at it from the stance that I have, being limited and like just being able to point out that, hey, you guys are forcing me to do this thing and they're not even allowing me to, they're not even giving me the opportunity to not proceed pro se. Now they are considering me pro se. They're holding me to the same standard as an attorney. And even though I've told them that I have no idea what to do at a trial, I'm not in the least bit prepared. So it's just sort of intimidating for me just going in because I'm used to the, arraignment process and how to speak to the judges, but in a trial situation, I'm just worried that they're going to threaten me with contempt if I say something wrong, and I'm not going to know quite what I'm doing wrong, in their eyes. So that's my biggest concern at this point.
Well, you're still going to be basically challenging the prosecution. You're at the trial, yep. So I do have, in the script, it does have voir dire questions, and you're holding the prosecutor to their burden of proof. They have to prove it beyond a reasonable doubt. You can't mention jury nullification or the judge will throw you in jail on the spot. That's my assumption based on what's happened so far. So you have to backdoor it by just saying they haven't met their burden of proof. And say things, look, because you can only discuss what's going to happen at the trial, and you can object to the prosecutor's opening and closing statements. If he's making claims you already know he can't prove, and you just, like when he says, and it will prove that the defendant broke the law, objection, counsel knows he doesn't have any evidence, and he knows he doesn't have a qualified witness to support that statement. He can only discuss the evidence that will be shown at trial, period. And we already have evidence of prosecutorial misconduct. The prosecution does not have the evidence. We've been through this for months. Now, the judge can say overruled, but the jury heard it, and then on your opportunity, you can say, "This is what's going to happen at the trial, ladies and gentlemen. They are going to desperately try to direct your attention away from the foundation of the prosecution's entire case, and that is that I'm physically in Portland or physically in Oregon. Their rules apply. Now, the rules are they have to have evidence to prove that, but they're going to argue that they don't. Don't let them get away with it. Don't let them get away with it. Make sure that they prove every element beyond a reasonable doubt. And even the judge is obligated to tell you, if they don't prove every element beyond a reasonable doubt, you must acquit."
Mm-hmm. So. Now, that's one thing that I was contemplating a lot is the opening statement portion, because I thought that I might, just try to explain it in great detail to the jury. But I was wondering, at what point will the judge stop me, or what types of things will the prosecution try to do to try to dissuade me from basically educating the jury on what has to be shown, what has to be proven.
Well, he may try to step all over it. He may not allow any discussion, and you have to object. Say objection, and talk right to the jury. Do you see how the judge is obstructing me and protecting the prosecution? If he threatens you, the judge is making the case for you. They've bullied me every step of the way. They bullied you here today. You're only here today because they forced you to be here. So I do have that. I do have these general voir dire stuff in the motion, in the script. Some of it's in the book, but a lot of it is in the script. Show all the due process violations to the jury. Talk right to them.
Okay. So it's okay then to bring up things that have happened at hearings, at the arraignment hearings?
You have to relate it to what's going to happen at trial. You have to relate, because the prosecution, you have to relate it to the prosecution's lack of, we're going to just go through the next segment. It's too important. Okay. Yeah, we're back here live on the No State Project, and I'm sorry for everyone. We're not getting to everybody. I do apologize for that, but I think the issues going on here Monday with Robbie have brought application to a lot of us that are listening to the show, and so we're going to finish this last short segment with Robbie. And if we didn't get to you today, then I apologize, and just know we are going to be live on February 1st, this Wednesday. We are commercial free, so tune in for that at 6 p.m. Eastern Standard Time. You go to markstevens.net for the link to watch that on my Ustream, and then it's, of course, posted on YouTube. So, Robbie, we're talking about the voir dire and how we are addressing the jury. And I know that the judge is not going to want you to talk about any pretrial stuff. And you have to make your objection, say, objection. This goes directly to what the prosecution's burden of proof is. And we already know that they don't have any evidence to prove this element, and you are allowing them to get away with it. And I don't think the jury should be shielded from that. I couldn't think of a better word. The judge may threaten you with contempt. I mean, there's Mike in Idaho, when after he hung the jury on the felonies, they brought in a ringer to go against him on the second trial, and he threatened him. We heard it. The judge threatened him. If you bring up the applicability of the code, you are going to jail for contempt, and we will put a lawyer in to do your trial. He was threatened. Wow. He pushed it a few times. I think he that showed a lot of guts. But you have to let the jury. I don't think he ever let the jury know. By the way, the judge has been bullying me the whole time. He doesn't want you to know that.
Right, and that's one thing that I really was hoping to have the opportunity to point out is the way that the prosecution has been bullying me, even on the record. Gaslighting me, convincing judges that I am. I've been informed and that this and this has happened, and it's like, why is the supposed fair and impartial judge taking the prosecution side and not even considering mine when there's two objecting statements, statements that are mutually exclusive, basically. So it's one thing that I was hoping to be able to say to the jury.
Yeah. See, the rule of opening statement and closing statement has to be, especially the opening, you can only discuss what's going to be shown at trial. If the prosecution's getting up, and like I mentioned off air, if the prosecution's going to get up and lie and say things that he cannot prove, and we know he doesn't have proof, you have every justification. It would be unfair not to let you object and point out the prosecution knows he doesn't have such evidence. He's lying to the jury.
Mm-hmm. So it's okay to object in the middle of the prosecution's opening statement?
Absolutely. Absolutely.
Okay.
What happened with Dave in Massachusetts, he got screwed by an attorney because the attorney, although he admitted you could object during opening and closing statements, he didn't like to do it. Dave wound up getting convicted. Now, would things have changed because the prosecution in his closing statement, and his lawyer agreed, lied and said that XYZ was proven when it wasn't. And so you are supposed to, yes. Well, don't you remember my cousin Vinny? We'll keep going back to that. Vinny gets up, and his opening statement was, everything that guy just said is BS. So what did the prosecutor? Objection, Your Honor. Move to strike the defense's opening statement. It's entirely argumentative and prejudicial. Right? So, yes, you can and should object to an opening statement if the prosecutor is talking about something you absolutely know he does not have and cannot prove at trial.
Okay.
You can then, on your opening statement, get up and discuss what will be shown at trial. Ladies and gentlemen, what will be shown at the trial is the prosecution is going to put a witness on a stand he knows doesn't have personal knowledge, and the judge is going to allow him to do that over my continued objection. And say, you were forced to be here. We know that. However, since you are here, let's not have there be a 13th victim here today. You have to make a decision based on the evidence that proves every element beyond a reasonable doubt. They want you to ignore the fact that an element of the charge is the applicability of their code. Now, they want you to just assume that for the prosecution. The judge may even tell you that. And I will object on grounds that it's an improper instruction. Mm-hmm. You can't, look, ladies and gentlemen, you all know it's a basic fundamental principle of logic. You cannot prove a rule was violated unless you first prove it applies. They want you to assume an element of the charge right out of the gate. Don't let them get away with it. You will see with your own eyes and hear with your own ears. This prosecutor will agree with me that his witness is not qualified. Why? I will ask him questions on cross-examination. I will ask him for evidence to prove an element of the crime. He will object. He will object not because he has a valid objection. He will object because he knows if the police officer has to answer that question, you will not convict me. At least one of you on this stand will refuse to convict me.
Mm-hmm. Yep.
I know in the past I've taught, and I talked about it in the book about the scorecard. At least in federal court, and I report from personal knowledge, it was not allowed. In my eyes, it was too effective. They actually said that he didn't get the elements of the charge right, which is ridiculous. I took the elements of the charge directly from a Supreme Court case. But they wouldn't allow it. Because it made it too easy to spoon feed the jury. It was too easy. Now, that's something you can bring out. Maybe they'll let you get away with that. You can just say, look, we can keep a scorecard here. This is the element of the charge, and this is the witness who, with personal first-hand knowledge, who testified to it. And they won't be able to do that. And that's something you bring out in your close. You saw the prosecution. You saw him impeach his own witness. Please, don't make the mistake and compound this tragedy by assuming an element for these people. They don't deserve it. They didn't ask you to be. I'm kind of monologuing now, but you get the point.
Yep. Yeah, that's good information. I'm definitely going to go back and listen to it again and prepare myself.
Well, I know you're going to do some role playing, and just you do a lot of it.
Yep.
It's just this is where the rubber meets the road. And Stahl's asking, what elements, Mark? Can post this stuff? Scorecard? And now I know our Canuck friend up there has not read the book, so we're going to have to somehow bring down the banhammer on our friend Jan. The elements, like in taxes, one of it was willfulness. But it's a code violation. It's mala prohibita. That's what they accused you of, mala prohibita. That's wrong because it's a code violation. So the code has to apply, and there has to then be evidence to show the code applies, and there has to be evidence to show you violate it. It's pretty common. It's basic. And if you can dumb it down, it makes it easier. And that's why I think it happened with James. It was too easy. If he had this big scorecard there, it may have changed the outcome. It may have. At least one person on that jury was, hey, he's got a point. I mean, I think he's guilty just because, that's what my my conditioning with. But I can't get away from the fact the prosecution didn't meet their burden. I was there when when they declared him incompetent. I was sitting right here. Yeah, but we know he's guilty anyway. He didn't pay tax. Yeah, but the judge did say it has to be beyond a reasonable doubt for every element. So spoon feed them. And you push it. Yes, you already know he's going to threaten you with contempt. But you're going to have to get your damage in up to the point where he's actually going to throw you in.
Yeah.
I mean, we don't want that, obviously. So push it as far as you can. Never interrupt the judge and spoon feed the jury. Every element beyond a reasonable doubt, unless the prosecution can offer some rational excuse why you should accept a double standard on two elements of the charge, you have to acquit if they can't prove one of them. You have to. You have to. Hey, I wish we had more time, but we are out of time for the live broadcast, and I've got to get this posted. But if you have any other questions leading up to Monday, don't hesitate to send them over, okay?
Okay. Thank you, Mark.
I appreciate the call, Robbie, in Portland, and we'll be in touch, and hopefully Monday we'll hear some nothing but good news. But my name is Mark Stevens. This has been the live broadcast for January 28th, 2017. We will be live for episode 10 on February 1st. So till then, salud.